In this building block video, I discuss personal guarantees and how they are typically eliminated or at least neutralized in a small business reorganization case. In a later case study video, we put the information learned here into a real life fact pattern and then analyze the results. A question I often get is this: what good is eliminating debt or reducing the amount owed or restructuring payment terms if the creditor can just come after me, a friend, or a relative on a personal guarantee? All right, there are a number of tools and strategies that can eliminate personal guarantees or significantly blunt their impact. So, in short, all is not lost if you, a friend, or relative sign personal guarantees on business equipment, purchases, unsecured lines of credit, or leases. Not even close. First, the court can and typically will issue an order under Section 105 of the Code barring the creditor from pursuing the personal guarantor of the debt while the reorganization plan is being put together and then while it is being implemented. The court's reasoning is that the purposes of the SBRA would be frustrated, rendered effectively useless, if the creditor could immediately pursue the guarantor, because doing that would deny the business owner of the opportunity to take advantage of a reorganization to which the business owner is entitled under the law. Creditors are also willing, in many cases, to withhold execution on the personal guarantees in exchange for certain concessions in the reorganization plan itself. Having the right to pursue a guarantor is not the same thing as getting paid. The guarantor may not have non-exempt assets to pursue. To even find out if the guarantor is liquid, the creditor has to sue, and getting that judgment could take years. Plus, contrary to popular belief, many creditors want to see the business succeed and are willing to negotiate, especially if they think or are led to think that the guarantor will, him or herself, file bankruptcy to wipe out the guarantees. A California resident can exempt a significant amount of assets and still wipe out the guarantees. Effective January 1, 2021, a California homeowner can exempt county median home value up to $600,000 or $300,000 in home equity, whichever is greater. With some advanced planning, a personal guarantor with significant assets could save their restaurant or other business through the SBRA, wipe out the personal guarantees, and still keep $500,000 or more in home equity, retirement plans, furniture, furnishings, jewelry, tools of the trade, and other assets. Agreed, filing a personal bankruptcy to save the business is not the ideal result, at least not emotionally. But you wouldn't be in business if you were faint-hearted, so sometimes what needs to be done has to be done. What would you rather see? One, lose a business you genuinely enjoy and then have to file for personal bankruptcy when the creditors come after you on the personal guarantees, or two, save the business by permanently eliminating, reducing, or restructuring debt and wiping out the personal guarantees with a personal bankruptcy and likely keep everything that you own. In another video blog, we look more closely at how filing a personal Chapter 7 or Chapter 13 bankruptcy can eliminate personal guarantees. With a little pre-planning, we can achieve for clients total or near total protection of personal assets. If you sense that there is an exit strategy, you're right. The threat of a personal bankruptcy to wipe out the personal guarantees gives the business owner leverage, considerable leverage in many cases, to bring the creditor to the bargaining table. Foreseeable end result: neither side gets their best case scenario. The creditor gets paid more through the restructuring plan than they would without the personal guarantees. The business owner doesn't get all the debt reduction they could without the personal guarantees, but the owner does reduce debt to the level where, post-COVID income is enough to become profitable again. Please check our video library and blog for other topics that may be of interest. Also, to find out more, you may wish to attend one of our upcoming webinars. Check the website for details. If you would like to discuss your company's particular situation, call or fill out the contact form. We look forward to hearing from you.